Hi there, welcome to another Tomkins Talks. It's time for a short snappy summary of a recent case in a form that's easy to digest, whether you're at home, in the office or on the move. Now you may have spotted that I'm out on location today. Why is that? Well, the case I'm going to talk about involved a spot of sanctuary and a residential development. And guess what? I'm standing here in one of what is my local spots of sanctuary. And if I turn around just behind me here, you should be able to see a residential development. Has nothing to do whatsoever with the case, but I thought it might be nice to get away from my desk for a while. Anyway, let's get started with the backstory. So I've moved out of the wind in the hope that you might be able to hear me a bit better down here. So what is the backstory? Now, land is often burdened by restrictive covenants, which are agreements between landowners restricting how they may use the land in question. When developers are looking to acquire sites, it's important they consider whether any restrictive covenants may frustrate their intentions for the land. If they do, developers can look at obtaining insurance to protect themselves against claims under the covenant. They can seek to obtain a release from the party benefiting from the covenant, or they can apply to the upper tribunal to seek to discharge the covenant. Now, developers, please do note, if you're going to seek a release or apply to the tribunal, then insurance will not be available. Now, in this case, the developer acquired a large site, part of which was burdened by a restrictive covenant, preventing use for anything other than as a car park. The covenant benefited Alexander Devine's Children Cancer Trust, who operated a hospice for children suffering from cancer, and were concerned to ensure that ill children could use the grounds in privacy without being overlooked by the development. Notwithstanding the covenant, and in full knowledge of it, the developer built out the scheme. It was obliged to construct affordable housing as part of the development, and it put 13 of these affordable units on land burdened by the covenant. So once the units were built, the developer applied to the upper tribunal for a discharge or a modification of the covenant on the ground that the covenant impeded a reasonable use of the land, it was contrary to the public interest, and that Alexander Devine could be compensated in money for the loss of the covenant. The developer succeeded in the upper tribunal, but Alexander Devine appealed to the Court of Appeal, where the tribunal's decision was overturned. So he went on to the Supreme Court. And what was the outcome there? So, in short, the court found for Alexander Devine and held that the covenant should not be discharged or modified. Whilst the court appreciated that it was appropriate to consider whether leaving the constructed units empty would be contrary to the public interest at a time where housing is needed, it had to balance this with the use of the benefiting land by Alexander Devine as a hospice for children suffering with cancer. One factor that appears to have been relevant in the court's decision was the conduct of the developer, which was said to be a cynical breach of covenant. Lord Burrows said, "It is not in the public interest that a person who deliberately breaches a restrictive covenant should be able to secure the modification of the covenant in reliance on the state of affairs created by their own deliberate breach." So what does this mean? Well, it's a reminder to developers that they should ignore restrictive covenants and continue to build despite them at their peril. If developers know of covenants and think that the tribunal may discharge or modify them on the public interest grounds, then this application should be made before construction commences. I hope you found this video useful. Please comment, like or share it if you did, and I'll see you again soon for another Tomkins Talks.